Lynette, can you hear us? Mr. Melvin? Mhm.
Or do you want him?
That's his attorney right there.
Okay, there you go.
Okay.
Good afternoon, Your Honor.
Ready?
Okay, Mr. Castle is ready, on Mr. Mitt.
Thanks. Good afternoon, Mr. Castle.
Hey, good afternoon, Your Honor.
Mr. Danforth, keep it down. I can hear you all the way 2 miles away. This is cause number CR 23-14, CR 23-229. State of Texas versus John Raymond Mintz. Show that Mr. Mintz is set for pretrial on continuous violence charge and docket call on the assault. Any announcements, Mr. Castle?
Judge, we don't have any pretrial at this point. And forgive me, I don't know when the proposed trial dates are.
Well, we
Off the
haven't said,
top of-
we haven't said anything, yet. And so I would be looking at, if you have no contested pretrial motions, I would be looking to set it to February, either, 13th, 15th, or 27th.
We are set, especially set on a capital murder in Longview with the AG's office for that. I think it's not the week of the 13th. Let me pull it up. We're set the 26th.
Right, you want to set it either the 13th or the 15th? That way you're not. double booked.
I hate to, let's see. The 13th is fine.
Are you still negotiating with the state at all in this case? If not, I mean, we can just go ahead and set it for trial today and dispense with the docket call if you're confident that you've already reached a point in this case where he's not going to be negotiating with the state.
I don't anticipate anything else coming out of those discussions.
Do you want to go ahead and just waive docket call announcement, waive the time to discuss, and it's just so long as Mr. Mitz knows if we set it for trial today, then we're set for trial, we're not leave later, wait till the Friday before, anything like that.
I'm fine with that, Judge.
Let's go ahead and set up trial. All right. We'll set Mr. Mitz then to begin, he'll enter upon the court's rolling trial docket. We'll start that the week of February 5th. Obviously, Mr. Castle is not required to be here on that date. Once Mr. Mitz gets into the top 10, we'll be sending out notices for those trials that we file to be called for trial. So he'll start on the 5th and we'll continue to resetting every week that we have a trial. And then we'll just,
Thank you, Your Honor.
Mr. Castle, so I don't have a clear record, can you tell me what offers, if any, the state made that Mr. Mitz has rejected so that I can have that on record?
I believe the last offer was 15 years. Yes. 15, Your Honor, is the last one that I've received.
Okay, all right, Mr. Mitz, then we'll place you on the court's trial docket beginning February 5th. And your case will start at the bottom and work its way up. Let's see, you're charged with assault. There's a chance and a possibility that somewhere down the line I could especially set that Mr. Cassell, so we'll see. But right now, we're going to talk about it.
Thank you, Your Honor.
Thank you, sir. Good afternoon, Mr. Lowe.
Good afternoon, Your Honor.
All right, this is Mr. Lyons.
Jonathan Lyons.
All right, this is cause number CR 23-221, State versus Jonathan Lee Lyons. Set for pretrial. Go ahead, Mr. President.
Your Honor, we had filed a motion to suppress. At this time, we're not urging it. We haven't really had any chance to negotiate any sort of plea bargain to it, so we're just going to reset.
Do you want me to set your motion to suppress for evidentiary hearing, or do you want me to set it?
Well, not at this time, Your Honor. I think I'd rather see if we can't negotiate, resolve, get a resolution before we set it for a pretrial. If that's possible.
We do both. How about we set it for pretrial and evidentiary hearing on the 29th? If you can't work out something between now and February 29th, then on the 29th, we'll take up your motion. That way, Mr. Lyons is not detained any longer.
Yes, sir. Be fine.
All right, so we're going to set it for pretrial. I'm just going to set it for evidentiary hearing on 2/29, and then that gives you time to try to work it out. If not, we'll hear your motion on the 20th.
I said, what month did you say, Your Honor?
February 29th.
February, okay.
February 29th, yes, last Thursday, leap year. You probably thought I was trying to go faster on it. Set it on February 29th.
That's right. All right, Your Honor, I got it. Thank you. That's all we have at this time.
Are you ready on, thank you, Mr. Lyons. You can step back. Are you ready on Mr. Danforth?
Yes, sir, Your Honor. We haven't really received, I think Mr. Hartwell's been real busy, and so we haven't really had a chance to have any complete negotiations. So I think.
Yes.
All right, for the record.
Yes, Your Honor, and I apologize, Mr. Lowe.
For the record, this is cause number CR 23-159. Want to make sure to make the record what we're talking about. Go ahead, Mr. Hartwell.
And I apologize, Mr. Lowe. I know you've reached out last week and this week, and I'll follow up with you this afternoon. And I think we'll be able to probably get this one moved.
Thank you, Your Honor. Thank you, Chris.
And Mr. Lowe, any contested pretrial motions that we need to set up?
Your Honor.
All right, so let's go ahead and we'll set this one for docket call. And I'll tell you what I'll do for you, Mr. Lowe, since you're already going to be here on the 29th, I'll just set this one for docket call on that day as well.
Thank you, Your Honor.
You're welcome.
That's all I have, Your Honor.
Thank you, Mr. Lowe.
Yes, sir. Thank you, Chris.
Plat is ready, Your Honor. It's on Mr. Melvin. I'm gonna make it over. Okay.
All right, this is cause numbers CR 17-63, CR 17-466, CR 20-58, State versus Joseph Edward Melvin. Show that we're set for, I'm not sure what was set, it says bond forfeiture, but obviously. Go ahead, Mr. White.
Your Honor, that was the only thing that I was actually notified on. And asked Ms. Taberham if I needed to be here because obviously I have no part of the bond forfeiture. And then I found out I was on the docket. I have to be honest with you, the last time I dealt with this case was back in October 2018. I've gone through my file this morning. It's not really ringing any bells with me right now. I haven't had a chance to speak with anybody on this because I didn't even know Mr. Melvin was incarcerated. So I'm pretty much up here going, I don't have a lot to say.
Give me a second, let me look this up. I'm guessing that Mr. Melvin was an absconder or something and had a bond forfeiture and has been picked up on that and is back in custody. It is my guess, but let me confirm.
That would be my guess as well.
Yeah, it looks like the court issued a judgment. I saw bond forfeiture back in October of 2018. KBS was issued and then it was executed December 19th of 23. Looks like, look back, this case existed prior to me taking the bench. Looks like arraignment was originally set back in March of 2017. A couple of arraignments, couple pretrial hearings, 3 docket call hearings, and then We went back to pre-trial. It looks like we were set to plea in August, set to plea again in September, set to plea again in October. And that's when all of that was 2019. So it looks like he failed to appear at his plea date on October 18th. So looks like that's where we're at this. So what I can do, Mr. White, is I can reset you for a final docket call. Give you time to get caught back up with Mr. Melvin and say. What do you think about that? We all able to hear me?
I can hear you.
Okay, so you want me to just reset the case for about 30 or 45 days, give you time to speak with the state and get,
I would appreciate that.
okay? How about February 27th? That's a Tuesday.
I'm assuming out here at the jail at 1:30.
Yes, sir.
That would be fine, Your Honor.
Okay, all right, of course, been set, and this will be the final document since he absconded and had all the other settings. I'm only gonna allow him one additional setting to make up his mind on what he wants to do. So it'll be
But that
February,
should give me some time to be able to speak with the state.
yes, sir. All right, so February 27th, 1:30, we'll see you and Mr. Bell back at that time.
Okay. Your Honor, could you give me the cause number on the last case? Because I don't actually, I'll go ahead and do it, but I don't,
I have them.
okay.
Yes, thank you, Patty. All right, thank you, Mr. Mellon.
Your Honor, we're gonna need a few minutes. One of our plea papers are incorrect. We're waiting on one defendant. Unless Mr. Ashmore is on Zoom yet.
Mr. Ashton on Zoom. While we're here, can you tell me, I want to know how, the attorney standing in for Parks Drive, how do I pronounce her last name? Is it Lukonen? Can you tell me?
Good afternoon, Your Honor. It's Jody Luukinen.
Lukinen,
Luukinen.
okay, all right, thank you. I just want to make sure that butchered you too bad when I called you. Okay, thank you.
And he had some kind of cart problems and said it would be 2 o'clock before he got here.
Okay,
But
well,
the defendant,
I appreciate you standing in for him.
Yeah, absolutely. Thank you.
If y'all wanna come in.
All right, this is cause number CR 23-61, State versus Johnny Lee McDinn. Court finds that Mr. Stripes indicated that he was not able to appear today. And the court is recognizing Miss McKinnon. What's the announcement?
Your Honor, it's my understanding, I'm talking to Mr. McMinn here just a few minutes ago, that there's a video that Mark has in possession that he's not been able to see yet. And so what he's requesting is we can reset the plea for a short time so he can get with Mark and view that video that he's not been able to do so far.
It's a little confusing that we were supposed to set the plea today and he hasn't watched the video presumably by today. So that's a little concerning to the court, but I hear what you're saying. All right, I'm gonna set a final plea, Mr. McMahon, and you don't take it or announce that you want a jury trial on the next day. I'm just gonna set you for jury trial, okay? All right, let's do, how about the February 13th? Can you do that, February 13th?
Yes, Your Honor.
All right, we're setting Mr. McMahon for, I'm just gonna call it docket call, because I don't know if it's gonna be clear or not. I'm gonna set it for docket call February 13th. That'll be the final call that needs to be either complete that day or I set for trial.
Okay, thank you. I appreciate it.
You're welcome.
Thank you.
Thank you.
Here you go. All right, Mr. Manning, who you ready?
Judge, Ms. Pettis.
Pettis, you report. This is file number CR 22-74, State versus Kaylee Renee Pettis. Motion to adjudicate, motion to vote. Is this a plea?
Yes, Judge.
No, I think that's. All right, before we get going, it looks like Ms. Pettis will be pleading true to the state's motion to adjudicate. They're recommending that her guilt be adjudicated, that her supervision be revoked, punishment be assessed at 9 months in state jail, with balance of her financial obligations, which includes $1,500 fine, $180 restitution, $290 court costs, $135 in reimbursement fees, and that she would be getting 91 days credit towards her sentence for the time that she's already spent in jail on this cause. Is that a plea of treat to all counts?
Yes, it is, Judge, and that's not quite our agreement. Our agreement was 6 months. There was a miscommunication on the paperwork, but it is 6 months, and we have the corrected judgment for that. That has already been sent over by the DA's office.
6 months. And the credit time is correct.
That is correct, Judge, and she will be pleading true to all counts.
All right, Ms. Pettis, if you'll raise your right hand, place your oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you can lower your hand. All right, Ms. Pettis, you appear before the court. You appeared before the court on October 13th of 2022 and entered into a plea agreement with the state. The court approved your agreement, and that was for possession of a controlled substance, milligram 1, less than 1 gram, a state jail felony. The court conferred a finding of guilt based on your plea agreement, placed you on community supervision for a period of 3 years. It was during that supervision period that the state filed a motion to adjudicate and revoke, alleging that you have violated the terms of your community supervision, and they have alleged that you violated in 10 different ways in the individual counts. Have you had enough time to review this motion with your attorney, Mr. Manning?
Yes, sir.
Do you feel like you understand everything that you've read and signed today as part of your plea agreement?
Yes, sir.
Are you pleased with the work that Mr. Manning's done for you?
Yes.
Mr. Manning, do you believe that Ms. Pettis is competent to enter into this agreement?
I do, Judge.
All right, Ms. Pettis, then When Mr. Manning, does Ms. Pettis waive the formal reading of the state's motion to adjudicate?
She does.
Okay, Ms. Pettis, I'm gonna ask you this time, how do you plead to counts 1 through 10 that are contained in that motion? Are counts 1 through 10 true or not true?
True.
And you're telling me that those allegations are true, because in fact they are true, you're not just saying that to get a plea. Is that right?
Yes.
And Ms. Pettis, has anyone threatened, force, pressure you to plead true to any of these counts?
No, sir.
Or does accept the defendant's pleading true to each count? Mr. Manning, any objection to the stipulation of evidence and the defendant's waiver of rights of pleading true?
No objection to stage one.
That is admitted and the court takes judicial notice of the defendant's judicial position. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Rest and close, Judge.
All right, Ms. Pettis, based on the evidence before the court and your pleas of true to 10 counts as alleged, the court finds that you have violated the terms of your community supervision. The court will follow the plea agreement you've reached with the state today. The court adjudicates your guilt. That means convicts you of the state jail felony offense of possession of a controlled substance and only one of less than 1 gram. The court assesses revokes your community supervision, assesses your punishment in the state jail division of TDC for a period of 6 months. The court orders you to pay the balance of your financial obligations as previously ordered, including fines, restitution, court costs, and reimbursement fees. And the court awards you 91 days credit towards that 6 months from time of court admitted jail in this case. The court hereby remands you to the custody of the sheriff so that he carry out the terms and conditions of the sentence. Please step over with Deputy Martinez to be fingerprinted. After you get out of prison status, you need to report here to the district clerk's office so you can make arrangements to pay off your fines and court costs. Otherwise, a warrant's been issued. You're going to go through this process. Okay.
Okay. Yes, sir.
All right, we'll step over with the deputy.
And Judge, next we're ready on Mr. Taylor Scott.
All right. All right, this is cause number CR 23-101, State versus Taylor, Ryan Scott for arraignment. Go ahead, Mr.
Good. And Judge, we've actually reached a plea agreement in this case. I would note that there is one correction to the jail credit time. I don't know what paperwork you have, but it should show that he's pleading to 4 years TDCJ with time to run concurrent with Kaufman County case number 22-50189-CC2-F. And there's no fine, no restitution, court cost amount of $290 and reimbursement of $70 with credit time for 175 days.
Okay. Yeah, my credit time said 44 days, so that's the state defense's agreement is how much?
175.
170. And state agrees to that, Mr. Rutland?
Yes, Your Honor.
Okay. All right, Mr. Scott, you'll raise your right hand. Mr. Scott, you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God.
So
All right, Mr. Scott, all right, Mr. Scott, your name is Taylor Ryan Scott, is that correct?
yes, sir.
Mr. Scott, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
You're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Yes, sir.
Like you've had enough time to talk to him about your case to the point that you've had all of your legal questions answered and that you fully understand everything that you've read and signed in your plea agreement?
Yes, sir.
Mr. Manning, you believe Mr. Scott to be competent,
He is, Judge.
and you've explained to him his rights and as they pertain to this case, is that correct?
I have.
And I showed that we were set for agreement on this case. However, today, you've indicated, as Mr. Scott, that he wishes to go ahead and resolve this case. Do you think that he's had enough time to fully appreciate the advice that you've given him?
Yes, Judge. As a matter of fact, this morning, I was able to come over and speak to my client. We were able to review some, not all of the discovery that was presented in his case. And he, at that time, was able to make a decision on whether or not he chose to accept the state's offer as offered this morning.
All right, thank you. All right, Mr. Scott, you are indicted with a second-degree felony of engaging in organized criminal activity that does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. You've already heard the plea agreement in this case that the state's recommending that upon your plea of guilty, that the court session punishment of 4 years confinement in prison to run concurrent with your following county case, and you would receive 175 days credit towards that sentence for time that you've already been in jail. In addition, you would have court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. Scott?
Yes, sir.
All right, understanding the plea agreement, understanding the range of punishment, Mr. Scott, how do you plead to engaging in organized criminal activity?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing the crime?
Yes, sir.
Mr. Scott, is anyone threatened to force you to plead guilty here today?
No, sir.
Court accepts the defendant's plea of guilt. Mr. Manning, any objections to the stipulation of evidence?
No objection to stage one.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Press and close, Judge.
All right, court's going to review the stipulation of evidence. All right, upon reviewing the stipulation of evidence, the court finds that there is sufficient evidence to convict Mr. Scott of this offense. The court will follow the plea agreement recommendation of the state. The court hereby convicts Taylor Ryan Scott of engaging in organized criminal activity. The court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institution Division. The court orders that sentence to run concurrent with Collin County, case number 22-50189. CC 2-F. The court also orders Mr. Scott to pay $290 in court costs and $70 in reimbursement fees. It awards Mr. Scott 175 days credit towards his sentence for the time he spent in jail on this cause already. Mr. Scott, once you're released from TDC, if your court costs and reimbursement fees are not paid off before you get out of TDC, then I need you to report to the district clerk's office on either getting paroled or released and pay off the court costs and reimbursement fees paid.
Yes, sir.
All right, Mr. Scott, you're hereby remanded to the custody of the sheriff, so you can carry out the terms and conditions of the sentence. Please step over to the meeting.
Thank you.
You're welcome. Thanks.
Judge, next I'm ready on Mr. Jackson, Jaquavian Jackson.
All right, this is cause number CR 21-361, State versus Jaquavian and Sean Jackson. Motion to adjudicate, motion to vote. Go ahead, Mr.
Judge, we request to be set on the next contested docket. I say that I may need to check that date to make sure that I don't have trial on that date.
The next one is January 30th. That's week after next on Tuesday,
Judge, if we could see the one in February.
29th.
Judge, I believe that will work. Yes, Judge, that will work.
29th.
Yes, Judge.
All right, court sets Mr. Jackson for contested hearing on February 29th.
Finally, Judge, I'm ready on Mr. Rogers.
All right, court calls cause numbers CR 23-240, 241, 242, 243, 244, 245, 246, 247. State of Texas versus Jaquadron Trayvon Rogers. And
Judge.
that for arraignment on all of these, is that correct?
Yes, Judge. We've had an opportunity to review all the indictments except for 244 and 246. His name is spelled correctly on all those indictments that we did review. He understands the charge against him. alleged in all the charges. And at this time, he pleads not guilty and requests to be set on the pretrial docket.
Do you need me to show you? 6.
Judge, if we can just confirm that the name that is on all the other 5 or 6 cases matches the indictment, then we do not need to review that. It's the same charge, same transaction or occurrence, just a different victim.
I'm not gonna, unless I'm looking at it, show it to you. Six.
If you could scroll down just a little bit. I guess. Judge, his name is spelled correctly. He understands the charge against him in this case.
But this one's
Judge, his name is spelled correctly. And if we could just see the alleged complaining witness. Judge, if we could just scroll down just a little bit. Judge, I don't know if our screen's froze or
yeah, let me see. Should be showing 246 right now.
yes, Judge, and that is he understands the charge against him, and at this time pleads not guilty to that as well.
Do you need, due to the number of cases, do you need more time on setting pretrial?
Judge, if you don't mind, I have downloaded the discovery that as it is presently available in the DA's office portal. And I've not had an opportunity to go over that with my client. And I imagine there will be multiple witness interviews that we need to go over and check.
Go March 26th.
Judge, that'll work. Is there a Thursday docket that week on the 28th?
It's for evidentiary hearing, yeah.
Okay. If it's all right,
Hang on, I forgot you got your Thursdays. We can do the 28th, that's fine.
okay, thank you, Judge.
Forgot that, I was thinking you were Tuesdays. All right, so court says Mr. Quaidren Rogers for pre-trial hearing of all of these cases on March 28th.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Sweeney.
Thank you, Judge.
Sit, Mr. Ashton. Mr. Ashworth on. So, well, let's see, what about Mr.?
I have Cody McCoy.
Yeah, he's set for arraignment. Is he represented?
No, sir, he has filled out a affidavit of indigency while we were here at the jail. We work in Tennessee, is that correct?
Yes, ma'am. I was currently in Tennessee for 6 months before they brought me back to Texas.
Okay.
And as soon as I get my parole transferred, I'll be going back to Tennessee.
So he qualifies for a court-appointed attorney. I was going to appoint Richard Smith. And then if we could reset him.
Set Mr. Boyd. You want to set Mr. Schmidt? Let's just go ahead and set him on the 30th. That is a Tuesday. That is the evidentiary docket. It's a week and a half. Hopefully, Mr. Schmidt will be feeling better by then. But since Mr. Boyd's here on role transfer, then maybe we can get something worked out sooner rather than later. So let's set it for January 30th.
Back with Cody.
All right, thank you.
And I'll send you the information on how to contact your attorney.
Okay, thank you.
All right, so Mr. Spriggs, only one we have left.
Yes, sir, and we have him in the courtroom.
Yes. All right, Mr. Spriggs, just hang out for me for a second. Let me see if we can find Mr. Ashmore. He's double booked today. I know he's in court in Tarrant County. So he's gonna appear soon. Let us reach out to him and see if we can't get him zoomed in, okay?
Okay.
Do you want me to do that or?
Yes, ma'am, if you don't mind.
Was it Anderson County or Anderson?
I thought I recognized. Which is also black here.
Yeah.
But I thought. Oh. It was an attorney actually here.
It'll be just a minute, Mr. Sprague. There's Mr. Ashmore.
That's what you'll go ahead and.
Yes, sir.
Come on up.
Afternoon, Judge.
Good afternoon. This is cause number ZR 21-371, Say versus Casey Lynn Spriggs, status on the cell phone forensic report, the experts, I believe. Any update from the state or the defense?
Yes, Your Honor, I can speak as to the cell phones. The Secret Service did finish doing the dump on them. Right now, the sheriff's office is currently going through all the data and compiling a report for us.
Do you estimate time?
Your Honor, I believe Ms. Curry spoke with Lieutenant Keltner and gave him really a timeline or a time frame of all the information to work with. So I expect we should have a report relatively quickly. I couldn't give the court an exact estimate, but I would guess probably within the next 30 days we would have a report.
Distraction.
Judge, I appreciate that very much. I have been in contact with the district attorney's office on the request for the cell phone discovery, which is probably the last piece of the puzzle that my client and I are requesting to fully evaluate the facts of the case. I've been daunted, as the court is aware, finding a mental health or mitigation expert willing to work in Van Zandt County. I haven't given up that search. Actually, Mr. Wax, who's the proposed expert that the court has declined retention of in this case, that's not a comment on that ruling. That's just a stating a fact. Has offered ideas and suggestions, and that's not exhaustive, but I also appreciate the state's diligence in continuing to get these cell phones scanned, dumped, and analyzed. I did stop by the state's office to confer about that and was told that this report would be forthcoming. So would ask the court for unfortunately, yet another discovery status check. Also, I want to tell the court and my client, Casey, one, I apologize for not being there in person. We were moved from number 2 to number 1 in a trial set in Tarrant County next week. This afternoon, and about a third to a half of the way to Tarrant County, that case resolved, which is why I'm in my office as opposed to being physically present in the Van Zandt County Justice Center. So I appreciate the accommodation from the court, and I'd want to let the court, Mr. Spriggs, know, I apologize for not being there in person.
All right, so what I would propose is let's set this on February 27th for the forensic analysis report to be completed.
Judge, I'm going to switch from the camera to my calendar. I'm still on the call. I'm just going to mute this and pop over and make sure that date is clear, if I may. Thanks, Judge. 227 at 1:30 works. Very much appreciate that.
Okay, all right, and Mr. Hartwell, you can just make sure that the sheriff's office knows we need this complete. I know they got other members got to work on, but we've been working on this for quite a long time.
Yes, sir.
We need to get this ball moving so that we can get a resolution for the state and so 227, I'd love to have all that complete so that we can move on and discuss whether Mr. Ashmore's got another expert that we can look at or whatever. So I want to get past this hurdle that we're on.
Yes, Judge.
Yes, sir.
All right, we'll see you back on February 27th at 1:30.
Thank you so much, Judge.
You're welcome. All right, Mrs. Abraham, is that complete everything on our docket? I haven't seen the others.
I think so.
All right.
See you
Adjourn.
back.
Thanks for your help. Thank you, Charlotte.
Yes, sir. Thank you.
You're welcome.